Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we have another lawyer behaving badly. She was a judge with bad judgment, and then she became an attorney with even worse judgment, and now she's neither a judge nor an attorney. So let's get into this. When I was growing up, the big thing about Chicago was Mayor Daley. Mayor Daley, who was a Democrat, he ran the city. He sort of had life tenure, really, as the mayor. He just kept getting reelected. They made a lot of references to the Daley machine. He engaged in machine politics, and it's well documented in history. And, this doesn't wash off on all of the other Democrats all over the country. This is a Chicago thing. And if you're familiar with Chicago, most people, I think, know that. So I think you'd expect that city politicians would tend to be a little bit on the shady side sometimes, particularly during the Daley years, but you would hope that that had kind of gone away with the passage of time, but it looks like maybe it didn't. In Illinois, judges are appointed and then I believe they are reelected or retained. There was a judge in Cook County called Pamela Manila Martin, and I have no information about whether she was a good judge or a bad judge. I just know that in the case that was brought before the Supreme Court and the Attorney Registration and Disciplinary Commission in Illinois, it looks to me like she had some pretty bad judgment as it related to her uncle. One of the things that attorneys can do when they get into trouble and they know that the attorney regulators are coming after them, is they can file a motion to have their name stricken from the roll of attorneys. That usually accomplishes a couple of things. One, it prevents having to go through an attorney discipline hearing. And of course, if you go through an attorney discipline hearing and you're found to have committed violations, you then owe the state for the amount of time, effort, and money put into that hearing. So if you want to avoid that, one way to do it is to say, hey, I'm guilty and take my license, please. And so that is the process in Illinois, and that seems to be what happened here. So this is Ms. Martin's motion pursuant to Supreme Court Rule 762. And it says, I was licensed to practice law in 1986, and I want to have my name stricken from the roll of attorneys. Filed contemporaneously with this motion are a statement of charges prepared by the administrator and movant's affidavit in support of this motion. And she respectfully requests the court enter an order striking her name. So if we go down here, we find her affidavit, and it says, I filed a motion to strike my name. I received and reviewed a copy of the administrator's statement of charges, and I believe the evidence would clearly and convincingly establish the facts and conclusions of misconduct set forth therein. My motion is very freely and voluntarily made. I understand the nature and consequences, and under penalties of perjury as provided by law, I certify the statements set forth are true and correct, yada, yada, yada. And then we get down to the statement of charges pursuant to Rule 762A, and this is the stuff that is compiled by the Attorney Registration and Disciplinary Commission, the ARDC. In other states, it's called the Office of Chief Disciplinary Counsel or Office of Bar Counsel, but in Illinois, it's the ARDC. And there was a 3-count complaint pending before ARDC's hearing board, charging movement with intentionally using for her own purposes approximately $240,000 in funds belonging to Oscar Lawton Wilkerson Jr., following his relocation to a nursing home, with making false statements to Wilkerson's physician and close friend about the balance in Wilkerson's investment, checking, and money market accounts after she'd closed those accounts, and with failing to produce documents in response to an ARDC subpoena. So the first charge was that in November of 2020, Maceo R. Ellison, MD, held a power of attorney for property authorizing him to act on behalf of his then 95-year-old friend, Oscar Lawton Wilkerson, Jr. And he wanted him put into a residential care facility, so he asked the Pamela Martin, who was the judge, then a judge, if she would help manage his financial affairs. She's a judge, she's also his niece, and she said, sure. So she agreed to assist Ellison and Wilkerson and to use Wilkerson's property, including funds he held in checking and money market savings account, an investment account, and proceeds of an insurance annuity policy and a private pension and Social Security benefits, solely for Mr. Wilkerson's benefit. So a month later, she resigns her position as a judge, and Wilkerson moves into Brookdale Senior Living in Overland Park in Illinois, sometimes referred to in this case as Brookdale. I just want to say right now that if any of my children ever put me into a nursing home, I'm coming back to haunt them. And the reason I say that is because I've been in maybe 2 out of 100 nursing homes that I would consider not equivalent to living on the street in the third world. There have been a number of cases that I've filed in nursing home cases that the people were just treated less well than prisoners of war. In one case, I had a gentleman who was confined to a wheelchair, and they used his cigarettes to burn him. Just horrible things. One lady was covered in ants, and they were crawling all over her body. And, you know, the nurses, when they finally got around to discovering it, did the right thing. They got her out of the bed and cleaned her up. But that's the kind of thing that should never, ever happen to someone in a nursing home. I would just say I don't ever want to be in a nursing home. And I feel badly for Mr. Wilkerson that was where he spent his last days. Sorry for that little bit of distraction, but there are just some things that when you think of them, you really need to say them. So let's get back to what happened to Mr. Wilkerson's money. So the disciplinary commission shows that he's got a Fifth Third bank account, a U.S. bank account, an Ameriprise investment account, monthly pension checks from his former employer, and a monthly payment of Social Security benefits. So even though she only started to take care of his funds as of December, on December 26th, she went to the bank and closed out his U.S. bank checking and money market savings account and got 2 cashier's checks representing the account's proceeds of $115,353.45. The balance in the Fifth Third account prior to account 8783, prior to the deposit, had been $2,739. She put those checks into the Fifth Third bank account. On the 29th, she wire transferred $110,000 out of the Fifth Third account ending in 8783 to a separate entity to purchase $110,000 in cryptocurrency that she held in her own name and over which she maintained exclusive control. Now you might be wondering, why cryptocurrency? Why would she turn it into cryptocurrency? Well, because it's going to be very, very hard to track that money because it's digitally stored. If there are certain cryptocurrency outlets that essentially make the funds untraceable, and Bitcoin being one of them. And it's very difficult to recover those funds. So she will have complete and total control over those funds. She can be ordered to disgorge those funds, but nobody can go to Bitcoin and say, you got to pay these funds out, because they're not in Illinois. They are not an Illinois corporation. They're off-site, extraterritorial, I believe is a proper term. So she did something that indicated sort of felonious intent here. She stole a whole bunch of money. She embezzled it, I think is actually the correct term, from her uncle, a guy who's 95 years old, living in a nursing home, and can't protect himself. That seems to me to be fairly low down. This is one reason why I always tell people to be very careful who you give a power of attorney to. Because if you give someone a power of attorney, they can do this exact thing. Continuing on with the ARDC pleading here, she had not received authority from either Wilkerson or Ellison to use funds in that way. So between February 2nd and February of 2021 and February 1 of 2023, Movement received and deposited into the three Fifth Third accounts an additional $214,213.44 worth of funds belonging to Mr. Wilkerson, including $119,714.94 from his Ameriprise investment account, a $60,000 wire transfer, and at least 21 monthly pension payments of $928.50. During that time, Movement continued to use Mr. Wilkerson's funds without authority to make additional cryptocurrency purchases and other expenditures for her own personal purposes. But she did make 8 payments to the nursing home in the amount of $68,000. As of April 6, 2021, Movement had made her last deposit of Mr. Wilkerson's funds into the Fifth Third bank account, and as of May 25th, she'd overdrawn the account. So 2 months later, July 20th, Fifth Third closes and charges off the account. On July 20th, Fifth Third closed and charged off the account. As of May 25th, Movement had made her last deposit of Wilkerson's funds into the Fifth Third bank account ending in 7128, so he had 2 accounts there. And on June 15th, she overdrew that account, and eventually they wound up charging off those accounts as well. As of February 1, Movement had received at least $314,566.89 of Wilkerson's funds and had expended only $68,000 toward his care. As of February 7th, Movement had used at least $246,203.80 of Wilkerson's funds without his authority for her own personal purposes. Movement's use of those funds constitutes conversion, which is a tort. It's an intentional tort. False statement concerning account balances and initiation of litigation. So essentially, she lied to Dr. Ellison and said, oh, no, he's got plenty of money in his accounts. He's got $120,000 in one and $50,000 in another. And in fact, those accounts had already been closed. They had 0 balances. In July, Ellison was contacted by Brookdale, July of 2022, and learned that Mr. Wilkerson's care was 2 months in arrears. And so they hired Dr. Ellison, and Mr. Wilkerson hired an attorney, Eric Puryear, to investigate Movement's handling of Wilkerson's finances. So the new lawyer tries to find Movement and get some information from her, and over several weeks, she just doesn't respond. She doesn't make any responses to his, requests for information. In September of 2022, Puryear files a complaint on Mr. Wilkerson's behalf against her in Circuit Court of Cook County, and alleging that she converted a whole bunch of funds and he didn't even know what the amount was. On December 5th, Movement filed an answer to the complaint in which she admitted that she'd wrongfully assumed control of Wilkerson's property, that she had no authority to use his funds for any other purpose, and that she intentionally deprived him of the funds to which he was entitled. Then on February 8th, 2023, he dies. The court, Anna Demacopoulos, entered a default judgment against Movement in the civil case in the amount of $1,229,384.31 based on Movement's failure to respond to Mr. Puryear's discovery requests. So then in February, the ARDC gets involved. They slap a subpoena on her, and she never responds to the subpoena. And as a result of that, these are the conclusions of misconduct: that she's guilty of conduct involving dishonesty, fraud, deceit, or misrepresentation by converting Mr. Wilkerson's funds; that she's guilty of failing to respond to a lawful demand for information from a disciplinary authority, and that's number 2. So those are the 2 things that they could definitely provide enough information to get a judgment that she was guilty of professional misconduct. And as a result, the Supreme Court ultimately accepted her tender of her license and struck her name from the roll of attorneys. Now, you might be wondering why they had to go through all of this and give the statement of charges and provide the disciplinary complaint and she had to sign an affidavit saying that she had actually done these acts. Well, the reason she had to do that was because you can't just walk into the Supreme Court and say, here, I resign as an attorney if you've got discipline pending. And the reason is because if you do that and they strike your name, then none of that misconduct was ever proved, and you would probably not have to establish good moral character again in order to get your license back 2 or 3 years down the road. So they absolutely insist that you come in and you admit everything that you did wrong. And that's a very good rule. Exploitation of the elderly is on the rise, I think. You see it a lot. As an attorney, particularly one who did nursing home cases, I would venture to say I was probably involved in 20 cases where people came and said, you know, my uncle is stealing from my aunt, my mother is stealing from my grandmother. Eventually what happens in those situations where sister doesn't want brother and brother doesn't want sister is the court will appoint the public administrator, somebody who is elected to a position where essentially their entire job is taking care of the finances of elderly people. So this is an attorney who obviously would have been disbarred if she had taken this to a disciplinary hearing. She, at the last moment, I guess, decided to do the right thing, admit her misconduct, and eventually, I hope she will make restitution to the estate. It's such a sad thing when people have these kinds of, I guess it's this need to steal money. I don't understand it. I've worked for everything I've ever gotten, and I've not stolen anybody's money, and I would never do that. So it pains me to see this kind of thing happen, and it paints lawyers and judges in an especially bad light. And that also is painful. But again, this arises in Cook County, so maybe it's just the status quo. I don't know. Any of you from Cook County, chime in and let me know. Tell me what you think. Thank you very much for watching. I appreciate all of my people who have subscribed. If you haven't subscribed by this point, I'm going to run my little commercial now. Hey, if you're enjoying this content, please feel free to like and subscribe. It really helps the channel and makes it possible for me to continue to do this. That's it. That's the commercial. Well, that's what I have for you today. Thank you so much for watching. Have a marvelous day and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.